Let's get started. My name is Bev Pierce. I am the corporate training manager here at RI Realtors. A lot of you know me. Welcome to You Be the Judge. So we are going to ask for some audience participation today. This is, we're kind of excited about this event. We're hoping it's going to be fun for you today. It's a satirical look at the professional standards hearing process. We recognize that we are going to be discussing some serious issues, but this is meant to be a parody. We know that all of you here today are probably among the most professional licensees in the state. We just want to try to deliver some important information in sort of a fun way. But this requires audience participation, so be ready. It's a role play scenario, and we have some great actors participating with us today. We have, of course, the great Monica Staff, RI Realtors General Counsel, who's always so gracious enough to participate in our events. And we have a couple of great volunteers. We have Jean Allard of Keystone Real Estate Group. She's also a volunteer, member of the Professional Development Committee. Thank you for joining us, Jean. We have John Dolan of Dolan O'Rourke Real Estate Services. He is the chair of our Risk Management Committee and also a member of the Diversity, Equity, Inclusion Committee. So thank you very much, John. You guys, both of you are always so willing to join us, and we appreciate that. We also need our audience to be actors today. So imagine you're on the hearing panel at a local board's professional standards hearing. As a member of the hearing panel, you would have the opportunity to ask questions to the complainant and the respondent. So start thinking about what questions you might ask. We're in webinar mode today, so we don't see or hear you, but that doesn't mean we don't want you to participate. We'll ask you to put those questions in the Q&A panel at the bottom of your screen. If you see a question someone else asked that you like, hit that thumbs up, and that will move the question up, okay? You're going to have a vote on the outcome of the hearings, so pay attention and make sure you participate in the poll at the end of each of the scenarios. Are you ready to get started? All right. All rise. The Honorable Judge Monica Staff is presiding.
Good morning, everybody. Good morning, Bev. Thanks for the intro. So I'm going to do a couple of housekeeping issues too before we get started. Bev explained to you about how the audience participation is going to work. And so we're just the quick intro is I get a lot of calls every month on the legal hotline about commission disputes and also ethical issues. So commission disputes, as you know, it can have thousands or tens of thousands of dollars at stake. So definitely serious issues, as Bev said. And an ethics complaint, you might have a member of the public or another realtor who has serious concerns about the conduct of another realtor. And usually the hearing panel, which you're going to be today, usually the hearing panel is 3 or 5 trained realtors. And then we're going to hear the cases with with our actors. The first one is going to be an ethics complaint, an arbitration request, and that will be a dispute over commission. So we're going to figure out who was the procuring cause and who is entitled to the money. And then the second case is going to be an ethics complaint involving an emotional support animal, or is it? So as Bev said, if you listen closely to the testimony, think of questions like, what would help you make your decision if you were on a hearing panel? A couple other quick things, differences between an actual proceeding. If we had an actual proceeding, are the parties themselves, the complainant and the respondent, would have a chance to ask each other questions. We're not going to do that today in the interest of time, and we also want to hear from you. What would help you make your decision? All right, and then 2 other things to think of with the arbitration, which will come first. One is when you make a decision on an arbitration request, 99% of the time, it's an all or nothing decision. So one person gets all of the money that's at stake. It's very, very rare to have any kind of a split decision. So that's what makes this even more serious. The other thing is with procuring cause, if you're not, I get lots and lots of calls about this. What the heck is procuring cause? The short definition of procuring cause is if the broker who produces a ready, willing, and able buyer to buy a property under conditions that are acceptable to the seller in an unbroken chain of events. And finally, before we get to our hearing. Normally I would attend an arbitration hearing or an ethics hearing to make sure that due process is followed. I don't get a vote, but today I do. Okay, let's get started. Order in the court. I call this arbitration hearing to order. Right before me are the complainant Ken Mills, the respondent Maria Jones. The question before us today is whether a cooperating broker with a buyer representation contract is entitled to compensation from the listing broker when his clients made an offer at the open house without him. So we're going to hear from the complainant first, and that is Ken Mills. Mr. Mills, please proceed.
Thank you, Your Honor. I filed this arbitration because Maria Jones won't pay me the $5,000 that she owes me. On July 1st, she listed the house at 292 Mill Street in Pawtucket in the MLS. I've been working with my buyer clients, Steve and Ling Jensen, since September of 2021. I've shown them dozens and dozens of properties. I've even written up 5 offers for them. You know how tight the market has been. One day, Steve and Ling were driving through Pawtucket when they happened to see a sign for an open house. They stopped in, walked through the house, and fell in love. The listing broker, Maria, pushed them into making an offer while they were there. Ling called me the next day, very excited, and asked me to help them with the inspections and the rest of the process, which of course I did. But after the closing, that broker told me she wasn't going to pay me a penny because I'm not the procuring cause. That's why I'm filing this arbitration. It's not my fault they went to an open house. She's just being greedy.
Is that the end of your statement, Mr. Mills?
For now.
Right. Let's move on to the respondent, Maria Jones. Please go ahead, Ms. Jones.
Okay, I'll tell you what really happened. I listed a house at 292 Armistead in Pawtucket. On July 26th, Steve and Lynn Jensen stopped by my open house. They loved the house and wanted to make an offer right away. I sat with them, put together a purchase and sales agreement, which they signed. I didn't know they were working with another broker until Ken Mills contacted me the next morning. He said he represented the Jensens and he had just sent me an offer form. The offer form was on a Massachusetts form. Massachusetts, and listed him as a co-broke. I told him that Ling and Steve had already signed a P&S with me, and if Ken Mills had done his job, Steve and Ling would never have come to my open house without him. And if he had a contract with him, they should pay him. I don't owe him anything. He's not the procuring cause.
Is that the end of your statement, Ms. Jones?
For now.
All right, let's hear from our hearing panel. Does anyone listening today have any questions you would like to ask either Mr. Mills or Ms. Jones? If you do, please put them in the Q&A. What would help you make your decision? And I can ask myself some questions. Okay, here we go. They're coming in. All right. Ms. Jones, did you ask, they would like to know, why didn't you ask if they were asking, sorry, why didn't Ms. Jones ask if they were working with an agent? So that is the question.
And may I respond, Judge?
You may.
I absolutely asked them. And in my sign-in sheet, I have a space where people can write the agent's name and contact that they're working with. That was left blank.
Thank you. Okay, this is a question to both parties. Let's start with Mr. Mills. Did you have your the buyers sign a mandatory real estate relationship disclosure?
Of course I did. I had them sign one at the first meeting, and in addition to that, they even signed an exclusive agency agreement.
Same question to Ms. Jones. Did you have them sign a mandatory real estate relationship disclosure?
Of course I did. because that's part of the whole offer. They have to show how they're represented. I was representing my seller, and as their agent, I was representing them as a facilitator. I explained the entire process, and they certainly looked at me like they'd never seen anything like that before.
Let's move on. Mr. Mills, did you have a buyer agency agreement?
I certainly did. They executed it in September of 2021.
Thank you. I think Ms. Jones, you may have already answered this, but let me ask this slightly different worded question. Did you ever ask if they were already working with an agent?
Of course I did. And the answer was no. Not in Rhode Island.
Great. Scrolling down, our hearing panel is very busy and have a lot of questions for you. Great. It's like a lot of the panelists are on the ball and have the same questions. All right. Okay, here is the question for each of you. When was each document signed? Let's start with Ms. Jones. So when did you have them sign the mandatory real estate relationship disclosure?
I had them sign it at the open house with the paperwork for the purchase and sales agreement, because I'd not met them prior to that, and they had never met me prior to that. I don't know when they met Mr. Mills.
Okay, Mr. Mills, same question. When did
Well,
you have
as
them
I
sign?
stated, Ms. Jones, I started working with them back in September of last year. And when I first started working with them, I had them sign a mandatory relationship disclosure and an exclusive buyer agency. I've got it around here somewhere.
Mr. Mills, is your buyer representation agreement still in effect?
I don't know. I can't remember what I drafted back in 2021. It's in here somewhere.
When was the last time you even talked to those people?
Ms. Jones will ask all the questions through me, the judge. Thank you.
Oh, I apologize. You're right.
Okay. All right, don't make me use this. All right. Was Mr. Mills, are you licensed in the state of Rhode Island?
I am.
And were you licensed at the time of when you signed the buyer representation agreement?
Absolutely.
All right. Ms. Jones, do you have any follow-up emails explaining the role of a transaction facilitator?
I don't have any emails about that, but they signed the form. I can certainly show it to you, because unlike Mr. Mills, my paperwork is right here.
Great. Thank you. Mr. Mills, why did you use the Massachusetts offer?
It was what I had handy. They had already apparently gone under agreement. They called me to talk about an inspection. I wanted to make sure that the documentation was filed with the listing agent, Ms. Jones.
Thank you. Great. Mr. Mills, did you send your clients any listings that would have included the Rhode Island open house?
Of course I did. I have them set up on an MLS strip in Massachusetts as well as Rhode Island, and that included the notification of the open house.
Thank you. Back to Ms. Jones again. In this market, how did you find the time to go through the relationship disclosure and the purchase and sales agreement while also assisting other buyers?
Because I waited until the open house was over, and I told them if they would patiently wait, I could write the paperwork up right then and give them the time that they deserve to be able to have that explained to them. And in that time, might I add, in that time, they could have contacted Mr. Mills if they even knew who the heck he was, never mentioned his name at all.
Clearly they know who I am. They called me right after they went under agreement, Maria.
I think the judge is the one that's supposed to ask questions.
Thank you. Yes, let's keep the comments. We don't need any cross chat going on. You can direct questions or comments to me. Mr. Mills, when was the last time that you contacted the clients?
I had spoken with them on the Friday before the open house.
And then Ms. Jones, when did you tell Mr. Mills that he would not be getting a commission?
I told him at the end of it. He came out of nowhere. And when everything was all said and done, he's sitting there with his hand out ready for a check. He's not procuring cause. If he wants to get paid, let the buyers pay him. If he's got that exclusive relationship.
Okay, so do you mean at the end of the transaction or after the buyers sign the purchase and sales agreement, the closing table?
At the end of the transaction.
All right, thank you. And Mr. Mills, did you ever complete both the Rhode Island and Massachusetts disclosure forms with your clients?
The disclosure forms for the relationship?
Doesn't say in the question, but let's go with that as a question.
Yes, as I stated earlier in my testimony, I had had them fill those out in September of 2021
And those were in both states.
for both states.
All right. Okay. And then were you showing them property in both states, Mr. Mills?
I was. They were looking across the border in both Massachusetts and Rhode Island, which is why it was so important that they had a buyer's agent that was licensed in both.
Thank you. All right. For a few questions. Mr. Mills, before the open house and the offer, when did you, I may have answered this already, but let's try again. Before the open house and the presentation of the offer, when did you last have contact with the buyers?
On the Friday preceding that weekend.
Okay, thank you. Sorry, I apologize. You did answer that question already. These are coming in fast and furious from our hearing panel, so got a lively crowd here. All right, let's see who else we have here. Okay. Where are the proof, and this is to, actually, this is to both of you. Let's start with Ms. Jones. Where are the proof of funds for the offer that was written up?
They had a pre-approval letter with them. And so I had that as part of that package that I filled out. They were walking around with that piece of paper with them.
And same question to Mr. Mills. When you wrote up the offer, did they have proof of funds?
They had proof of funds. We've been working together for over a year at this point, and of course, they had proof of funds with a pre-approval letter from their lender.
All right. Let's see. I think we just have a few more here. All right. We did have a question earlier that I had skipped over. This is to Ms. Jones. Were you a transaction facilitator or a dual facilitator?
I was a transaction facilitator for them. I explained that I was representing the seller. So they understood what their representation was, which was just to facilitate their piece. I did not advise them in any way, shape, or form.
All right, thank you. All right. Then this comment is, it comes down to the consumer. When the client was made aware of, when the clients were made aware of this issue, who did they say they wanted to represent them? Let's go with Ms. Jones first, then followed up by Mr. Mills. So when did the client say that who they wanted to have represent them?
Well, when they signed the paperwork with me, they just said that they were fine with me filling out the paperwork for them. They were fine with that. They never even mentioned Mr. Mills until farther down the road when they wanted to do inspections, and they said they were contacted by someone that would help them, which was certainly their right.
Same question to Mr. Mills.
They were not made aware that there was any dispute of representation until the closing, because I was not made aware that she wasn't going to pay me. I stepped in as soon as the purchase contract was executed, continuing with them through inspections and the rest of the negotiations up until the closing. And only then did the greedy Ms. Jones decide to lay it on me that she was keeping all of the cash.
All right, we don't need any name calling here. Thank you. All right. Ms. Jones, did you want to respond to that?
Well, being a Christian woman, the things I'd like to say, I can't.
All right, I will take that as a no then. We just have a few more questions. And this is to Ms. Jones. Why did you ask Mr. Mills to attend the inspections?
I did not ask him to attend the inspections. he injected himself into this transaction partway through it.
All right. All right, this is to Mr. Mills. Do you have any phone records to prove your claim that the clients called you the next morning?
I certainly have the received call in my call log. Yes, I don't have any written conversation about it. It was a phone call from Ling.
Thank you. Did the clients, and this will be to both of you, we'll start with Mr. Mills. Did the clients receive copies of all the executed documents? So that would be, I believe you answered the disclosures before, so that would be the purchase and sales agreement.
I certainly gave them a copy of the paperwork that they signed when they signed it with me.
And Ms. Jones?
Would that be the Massachusetts paperwork that wasn't even applicable in this circumstance? That's hardly valid. I mean, it's a Rhode Island transaction, and the purchase and sales was written up on Rhode Island forms because I wrote them up. You had this, sorry for my language, Judge, you had this half-assed paperwork filled out from a state that wasn't even applicable. Who cares if you have a copy of that? It's useless.
Okay, we don't need the editorial comments, but thank you.
Yeah.
All right. Was the pre-approval letter currently updated? So let me ask Mr. Mills first, and then we'll go with Ms. Jones. Was the pre-approval letter currently updated?
I mean, I've had so many copies of it. I'm not sure which letter they provided to Ms. Jones, but I've certainly kept up with them and the lender throughout the process.
Okay, very good. And Ms. Jones, how updated was the pre-approval letter?
It was updated. They just did it through Rocket Mortgage, so they just went online and printed it.
Okay. All right, looks like we've got about 5 or 6 more questions here. Mr. Mills, did you send a commission statement to Ms. Jones before the closing?
I did, and I copied the attorneys.
Okay, very good. Ms. Jones, why didn't you alert Mr. Mills sooner that he wasn't going to get paid?
It didn't come up. I was always of the understanding that we are supposed to cooperate, but not necessarily compensate.
And Mr. Mills, in your buyer representation contract, what is written in the compensation section?
Whatever is being offered by the cooperating broker in the MLS for compensation.
Okay. And so is the buyer responsible for paying that if you're not paid?
Oh, gosh. Again, I can't put my hand on it right now. It's somewhere in this mess of an office.
Who was the agent on the purchase and sales agreement itself that was signed by all parties? Who was listed as the cooperating broker or the person representing the buyers? So Ms. Jones, I'll ask you that question first. Who was listed as representing buyers?
My contact information was the only one that was on there because that was the only reason that I had, is because I was representing the seller. And again, facilitating the transaction for the buyer. So Mr. Mills' contact info is nowhere on there because for all I know, he was just in Massachusetts and he had nothing to do with the procuring cause of this whole transaction.
Yeah, Mr. Mills, whose name was on?
That's absurd. My name was on the offer paperwork that I sent over. It's not my fault Ms. Jones would not have her client review and sign the paperwork I provided.
And Mr. Mills, so did you not notice that you were not listed on the purchase and sales agreement?
She drafted that. I never received a copy of the purchase and sales. The next day when Ling called me, I drafted the offer form and sent it over to her. It was never returned.
All right, we're going to curb questions. We just got a couple more. Ms. Mills, did you call the lender to check the buyer's pre-approval or proof of funds?
Not sure which one of us that's supposed to be. You said Miss Mills, so I don't know.
That was the question was worded that way. Sorry, Ms. Jones, did you call the lender to check the buyer's pre-approval?
I did not.
Great. We have one more question here. So after initial, so this is going to be to Ms. Jones. After initially filling out the purchase and sales agreement or preparing the purchase and sales agreement, did you continue following up with the buyers, or did you allow Mr. Mills to continue with walking them through the inspections, mortgage contingency, et cetera?
I explained to them what I was duly supposed to explain, which is these are the opportunities, these are the rights that you have as a person who's a buyer who's not represented. These are the things that you have in front of you. Do with it what you will.
All right, thank you. Mr. Mills,
I continued to work with them throughout the entire process. As soon as I was made aware that they had found a property, we jumped right in, hiring the inspector, getting in. I coordinated all of the appointments with Maria and was not made aware of any issue as far as compensation is concerned until the closing table.
all right. Thank you both. Hearing panel, I think we're going to be done with our questions at this point. So I'm going to excuse the parties so that the hearing panel can deliver. And Ms. Jones and Mr. Mills, we will inform you of the decision later on today.
Thank you, Your Honor.
Well, thank you very much. Okay, court stands in recess. Right, and I'm going to turn things over to Bev Pierce, my bailiff, and she's going to walk you through a poll. This will give you a chance to vote. Ms. Pierce, please go ahead.
Thank you, Your Honor. I think Anne might be joining us here for a moment. I think she might have a couple of words to say during recess, and we will present a poll here for you guys in just a minute.
Yeah. Hi, everyone. Well, thanks for joining us. Right now, we've got 73 people participating, which is a really good number. So thank you for taking the time out of your busy day, and also for the great questions and comments that the Honorable Judge staff, Hingham High staff, is reviewing right now. As you can see, there are many facets to this environment. So we look forward to seeing what Hingham High's verdict is, so to speak. So how did we get to this kind of edutainment environment? Well, for two reasons. First of all, I'd like to give a huge shout out to my friend and fellow realtor, Tom St. Clair. He actually approached me a year, maybe even longer than that now, with COVID kind of in the middle, and said that he had a program. I believe he had delivered either in his office or at Kent Washington Association, and it was called Here Come the Judge, where he would robe out and we would present, different scenarios that had happened. Obviously, confidential information was not imparted, but I thought, oh my God, that's crazy. I would give up a couple of hours of my time to actually see what the process looks like and how, judgments are made, so to speak. So, first of all, kudos to Tom. Secondly, a couple of years ago, I was in Lake Tahoe at a CRS celebration convention, and they had a session that was called WTF. We kind of pondered on whether we should call our program that. We rendered it WTH. And then with Tom's help, it was like, well, let's do something called You Be the Judge. So it's, case scenarios like we have in front of you today, but you get to vote after, we come back together. You get to vote on who you think should win. So that will be happening in a few minutes once Monica has some time, because at professional standards, it's not a cookie cutter. As you know, we're using Monica, if I can affectionately use the word use. I don't mean that the way it kind of sounds, but huge kudos to you for being the judge, because in a true professional standards hearing, you would have a panel. It wouldn't be down to one person rendering the decision. But again, this is kind of like a hybrid situation, because in some of these instances, you may have to go to court. small claims court comes to mind, obviously with the commission on, within that purview. And if you've never been in front of a judge, well, now you kind of have an idea of what it's like. You have to have your testimony. You have to have your, I's dotted and your T's crossed. And that's a message that we're trying to convey at this point. So the Honorable Judge Hingham High staff, are you ready to take a vote from our audience members? And Beverly, how are we going to facilitate this?
Yes, we are.
Did you want to put the poll, your other poll up first, in the middle here, or did you want to do the?
Sorry, I got so excited about the
Okay.
vote, I forgot. So, part of what we're doing here is to try and figure out what needs you have, what concerns, what questions, what areas of our business you would really like to navigate. And so what we're hoping to do is use Monica's legal hotline and figure out what's important to you. What are the hot spots in your business based on questions that you've posed to Monica. So we will be issuing a poll. Here it is. We're not going to do it now because obviously we're in the middle of a hearing, but a lot of these questions we need your feedback on. So please don't rush out at the end of the program. We're kind of building enough time into that, kind of closing comments to give you a few minutes to complete the poll. What I'm hoping to do starting in 23, Code of Ethics traditionally has always been lecture style, has always been 3 hours all at once. What I'm trying to do in 23 is organize a program that will kind of split Code of Ethics training into a carousel of maybe 1 CE events. If the panel agrees, can we ask participants to do the poll now, or would you prefer, Judge, to wait until the end to complete it? The decision is yours.
Yes.
All right, I think the Honorable Judge says we're going to wait on that. So.
Okay. Well, this is what it looks like. There are a few questions. It's only going to take you maybe 2 or 3 minutes at the end. So please don't rush away and work with us on this because it's going to help us do some really cool planning along these lines, for 23. So on that note, Judge, you can hit the gavel and tell me to be quiet.
All right. So at this point, hearing panel, you had some excellent questions. If this were a real hearing, this would be our chance to discuss. And so we're going to have a vote here that you see on your screen. Do you have any tricks that they need to decide who you're voting for? Mr. Mills, Ken Mills, or Maria Jones?
No, it's all anonymous. And by the way, if you're on a mobile, you may need to tap on the screen at the bottom to see the poll. So if it doesn't pop right up, look on your toolbar and let's see how you're voting. We've got about half of you so far, and we'll give you a little bit more time. We want to see as many votes as we can get here. Oh, they're pouring in, Your Honor.
Excellent.
All right, they're slowing down a little bit. I'm going to give you another 10 or 20 seconds to get your vote in.
And as you're voting, okay.
That is it here. Shall I share the results, Your Honor?
Yes, please, bailiff.
Okay, there you go.
All right, so we have the procuring cause is drum 62% of you have voted to award the commission to Ken Mills. 38% of you voted to award the commission to Maria Jones. All right, so we can share these results here. What I'm going to do is actually, since I like to be a contrarian, I'm actually going to vote the opposite way, and I'll tell you all why. Part of it is because I'm privy to some things that you're not seeing. But what we would actually do in an arbitration hearing, again, I normally don't get a vote, so I'm kind of full of power, getting power hungry today here, but what we would do is go through an arbitration worksheet. So this is a series of about 20 questions. We're not going to go through all of them in the interest of time, but I know Bev has put together some handouts, so this is something that you'd be able to take a look at later, or if you don't have it, you can contact me and I'd be happy to send it to you. But if you ever file for an arbitration or if you're on a hearing panel, these are some of the kind of questions we would ask. So let me tell you what I zeroed in on. That definition of procuring cause, it's in an unbroken chain of events. Who procures the buyer, who gets the buyer to the point where they're ready to purchase. So in this case, if Ken Mills had actually introduced the buyers to this particular property, now I know there was one question where he had said that he had sent them some info. Oh, and here's the arbitration worksheet in the chat, if you want to take a look at that. Okay, so I can stop my screen share if you want to do that. Part of this boils down to the credibility of the parties. So what I would say is initially Mr. Mills in his testimony had not said anything about introducing the parties or sending them any information about this property. Now, during one of the questions in the hearing panel, he said that he did. I had to weigh his credibility, his demeanor, and sometimes that's what you'll see. On paper, it might look clearly that one side is one over the other, but when you actually hear them speak, then you have questions that call into mind. I think some of you had some questions about Maria Mills, and did she actually explain whom she represented in the transaction? Or was there any kind of interference there? You know, these are some of the types of questions that come up too. And how was the first introduction to the property made? In your case, it sounds like you believed Ken Mills, that he was the one who made the first introduction to the property. I don't know why the buyers would have gone directly to Maria Jones. So I found, even though I did have some issues with her credibility as well, I'd say that overall, since the buyers came directly to her, they did not contact their buyer representative about the property until after this. So he presented an offer the day after, was on Massachusetts paperwork. And so going through, so I'd actually gone through as they were speaking and as you were asking questions, I went through this whole list of questions. I think sometimes what can get a little bit confusing is you can have someone whose name appears or doesn't appear on the purchase and sales agreement. That by itself doesn't mean the person's procuring cause. Someone can have a buyer representation agreement, as Mr. Mills did, but that alone doesn't entitle him to compensation from the listing broker. May entitle him to compensation in general from his buyer clients, but not necessarily to the listing broker. So anyway, if you're an actual hearing panel, we would go through this entire list, ask all these questions that you'll see, and Bev had posted that in the Q&A. So based on all these factors, like I said, I don't want to go through every single one of them, but based on all these factors, fair or as unfair as it may seem, I would rule in favor of Maria Jones and not award Mr. Mills any money. So, and you're free to disagree with me, but that is my ruling. All right.
Your Honor, if I may, there are a couple of questions. Would it be okay to answer those now in regards to what we're talking about?
Absolutely.
Okay. Would you like me to read them or?
Sure, please go
Okay.
ahead.
Thank you. Does an automatic matrix email count as introduction to the property? So our MLS people can automatically send stuff out of matrix. Does that count as introduction?
It can, but I would want to see more than that.
Would it have mattered if Mr. Mills sent the offer statement on a Rhode Island form?
That isn't specifically one of the questions, but I would say that hearing panel would take them into consideration, want to find out. That's why I think some of you asked questions about the licensing. You know, was he actually licensed in Rhode Island, and why wasn't he using the proper paperwork? You know, whether he behaved competently could end up as a license law issue or an ethics issue. But yeah, I mean, that's certainly something I think most of us raised our eyebrows at. Why would he put that on Massachusetts paperwork when this is a property in Rhode Island? So then okay, go ahead. Go ahead, Bailiff Pierce. Bailiff
Last one, Your Honor. So what would be the best way for a buyer representative to avoid this situation when buyers go to open houses alone or without them?
Mm-hmm. Yeah, a lot of that is prevention. And actually, one of the handouts that we do have for you is something that our risk management committee put together. It's procuring cause, frequently asked questions. So doing some tips in there. But what I would say in general would be make sure that buyers understand how you're paid. If you're working directly with a buyer, whether you use a buyer representation contract or whether you don't, have you ever sat down and talked with the buyers to explain, hey, as I work with you, this is how I get paid. I'm going to get paid by the listing broker. So if you go and see a property, if it's something that interests you, make sure and take my card. Make sure and text or call me or reach someone from my office before you walk into that open house. Also, certainly I'd expect you to call. And I know that might be another issue that might have been throwing people about why I ruled the way that I did. I think that a lot of people have the idea that an open house is kind of a get out of jail free card. It doesn't really count. Someone just kind of pops in spontaneously. Yeah, I think many of realtors treat it that way, but that doesn't mean that it doesn't mean that person can't have procuring cause under those circumstances. That might be kind of, kindness or giving someone else a break, but it doesn't necessarily match the screen sharing here. It doesn't necessarily match the arbitration factors. So I think, was there anything else? Was there a raised hand up or
There is another question. There was a comment, about even though somebody voted for Mr. Mills, the person was concerned because he couldn't produce paperwork. And yes, our actor portrayed very well an unprepared hearing attendee, I would say. How do you feel about licensees introducing clients to the other agent as intending to attend the open house? So I guess introducing them ahead of time before having them go?
Yeah, absolutely. If you a text, email, call, if you know that your clients, and that's part of your counseling session with your buyer clients, make sure that they know to do that they realize that you don't want them just popping in on their own without letting you know, without having any conversation. So yeah, absolutely. If you know your clients are interested in the property, ideally you would call ahead or, contact the listing broker ahead of time and say, hey, is it okay if I send my clients over? Will you honor my commission? Some listing brokers, and I'd say a lot would probably honor that. Others would say, nope, I want you to be there. Yeah.
And finally, do you ever do partial commission? I think we'll probably have to stop at that one for sense of time. We want to make sure we have enough time to do our second scenario. So partial commission?
Almost never. It's all or nothing. We go by the National Association of Realtors Code of Ethics and Arbitration Manual. So the only time that you might have a kind of a commission split in the decision would be if there may be like a referral agreement or some other written agreement where they discussed having just part of the compensation. That's when you could have a split award, but otherwise, no, it's all or nothing. So in this case, you can see why it's important to be preventive and have these discussions with your clients, because ahead of time on the buy side, and just so that they know what to expect. If they don't do the impulsive thing. I can't tell you how many times I've heard at arbitration hearings, someone saying, oh, I didn't want to bother my agent. No, bother your agent. Bother your agent.
Right.
Yeah.
There is one more that snuck in here.
Okay, we'll cover this one really fast and we'll move on to our ethics complaint. So
yeah, and then we'll need to move on. After working with clients for over a year, sometimes clients stop at open houses. Once Mr. Jones contacted the listing broker the next day, or Mr. Mills, I guess, contacted the listing broker the next day. Wouldn't this be misunderstood that they did have actual representation? And some listing brokers will actually tell clients if they submit an offer with them, then they can negotiate the price because the seller wouldn't need to pay the co-broke.
Yeah, that's true that some listing brokers do that. That would be one of the factors on that chart that I was going through really quickly was interference. So if the listing broker, if there had been any questions or testimony indicating that they'd said, no, you need to work with him. The other thing I'll mention is since there was a buyer representation contract still in effect, had the listing broker known that, she couldn't, initiate contact with the buyers. But where the buyers approached her directly, at least that's what I believe based on the testimony, where they approached her and she didn't contact them knowing that they were an exclusive. It appears, and we can find a way that credibility differently, but it appears that she did give them a mandatory real estate relationship disclosure and ask questions. So yeah, as long as she did that and they approached her, that's an exception to that. And yeah, and I see one of the questions is interfering in another agent's relationship. Yeah, but even whether it's with the listing contract or buyer representation agreement, if the client is the one who initiates contact with the other side. So in this case, if the buyer's initiated contact with the listing broker, or a listing broker, or a buyer rep, a seller who is exclusively represented in a listing contract, initiated contact with another realtor, you can have the discussion, but you certainly can't initiate that and try and get them to break their contract. Okay, so I think that there are a lot of, I see some other comments here. Anyway, these are fantastic comments, but as Bailiff Bev said, I think we're going to have to move on to our ethics complaint. But everyone's done a great job. Wonderful questions so far. You're going to put me out of business as a judge, which is probably why I don't get a vote.
Just one more quick thing before we move on. If you guys have a question, remember to put it in the Q&A, because if you do raise your hand, unfortunately, with the number of attendees, it's going to be a little difficult for us to put you on to a microphone. So just throw those questions in the Q&A for us. Thank you.
And any questions we can't answer, it will be reviewed. This session is going to be recorded. Once we kind of do some editing and whatnot to kind of make it, more suitable for review. But everything that you put in the Q&A is going to be reviewed for future use.
Okay. And also remember to hang on till the end, because we're going to have a survey for you about what you'd like to see in future presentations. That was something that Ann had spoken to you during the break while we were in recess. So now we're going to move on to an ethics case. The one thing you're going to notice that's a little bit different about this ethics case is that we don't have any sections of the Code of Ethics that are cited here. Sometimes complaints will come in that way to a local association or the state association. Someone on staff would actually work with the person to kind of plug in. So before it actually got to a hearing, they would actually plug in, work with the person to figure out what about this conduct potentially violates the Realtor Code of Ethics. Here, I know Bev has a handout with the Code of Ethics. You may, if you want to just sit back and relax, that's fine too. If you want to go through the Code of Ethics and see anything that might fit as you listen to the testimony, please feel free to do that. All right, so our Code of Ethics case, we're going to call the court back into session. And before me and before us is whether a realtor violated the Code of Ethics by telling a buyer, claimed to have an emotional support animal, that the seller would never accept her offer due to the condo association's no pets policy. So we're going to hear from a member of the public, Marissa Jarvis, followed by the respondent, Dwight Canner. All right, Ms. Jarvis, are you ready to begin?
Now I am, now that I've unmuted myself, yes.
All right, please go right ahead.
Okay. I'm a little excited. I'm a little nervous about this whole thing. I'm filing this complaint against Dwight Canner because he hates dogs and he discriminated against mine. Dwight is a salesperson with Seabreeze Real Estate, and he listed unit number 130 in the Moonshine Complex on Sandy Way in Tiverton for sale. I texted him. He showed me the unit on August 5th, and he said he lives in the building too. I liked the condominium because it was really sunny and had lots of open space. And when Dwight helped me write up an offer, I happened to mention how the condominium had a perfect spot for my Great Dane Roscoe to walk. Dwight told me that the condominium rules allowed dogs that were only 15 pounds or less. I told him that the rules don't apply because Roscoe is my emotional support animal. Dwight said that Roscoe is too large for the condominium. I told him again that Roscoe is a support animal and not a pet. Dwight said that the association had had problems with fake support animals and had the nerve to ask me what was wrong with me. I told him that's none of his business and he was discriminating against me. He said that the seller would never accept my offer. I told him that I would sick Roscoe on him if he did. Roscoe was waiting downstairs in my car. As you can imagine, I was upset, and Dwight Canner should be punished.
Right, thank you, Ms. Jarvis. Was that the end of your testimony?
For now, yes.
Okay, no, I understand this can be stressful for everybody involved in ethics hearings, so, all right. Let's take a moment to compose yourself and we will move on to Mr. Canner. Okay. And Dwight Canner, please go ahead with your testimony.
Thank you, Your Honor. I did indeed list Unit 130 at the Moontide Complex, and Marissa called to make an appointment, so I did show her the condo. She really loved it and wanted to make an offer right on the spot. She never mentioned that she had an emotional support animal or the fact that it was a Great Dane until she signed the purchase and sale. Do you know how big those Great Danes are? It's the size of a horse. I let her know that the condo association only allowed dogs that weighed 15 pounds or less. And that's when Marissa claimed that it was an emotional support animal. If it was really a support animal, I questioned, why was it in the car instead of up at the showing with her? I asked her if she was able to provide any documentation of the training that Roscoe had been through, and that's when she claimed discrimination. So the condo association would never approve a Great Dane. I was trying to do her a favor by offering to, withdraw her offer.
All right, and is that the end of your testimony, Mr. Canner?
It is, Your Honor.
All right, let's see if our hearing panel has any questions. Hearing panel, any other information you'd like to know from either party, please go ahead and post in the Q&A. We're just going to wait a moment here, folks. Hey, Mr. Canner, why didn't you let the condo association decide about the animal?
Well, the condo association rules state very clearly 15 pounds or larger. I just wanted to make sure that her offer was being presented in the most favorable light by requesting documentation of the training, proof of that emotional support animal.
Thank you. An emotional support animal is, and this is going to be to Ms. Jarvis, an emotional support animal is not a pet. Do you have any documentation that you have that Roscoe is an emotional support animal?
But of course I do. He's got the, the saddle. Well, it's not a saddle, but he could use one. He has the whole support animal rescue thing on his back.
Hey,
I went through the paperwork. I'm sorry, I just can't get my thoughts together.
That's all right. Take your time. Okay. Ms. Jarvis, sorry, this is for you again, but if you need an emotional support animal, why wasn't Roscoe with you during the showing?
I had just fed him and I was afraid that he might have to go to the bathroom and I didn't want to make a mess.
Great. Mr. Canner, this is for you. When were you told by Ms. Jarvis that she had an emotional support animal?
The first mention of Roscoe occurred after the purchase and sales agreement had been signed by the buyer.
And Ms. Jarvis, the same question to you. When did you tell Mr. Canner that you had an emotional support animal?
It's correct. It was when I filled out that paperwork. But I know he's an emotional support animal, so there was no need for me to mention it at all.
All right. Emotional support animals do not require, and this is going to be to Mr. Canner. Emotional support animals do not require training. A letter from a doctor would be required. Mr. Canner, why didn't you request that letter?
I was requesting any documentation proving that it was an emotional support animal. I didn't want to inquire about what the need for that was. Simply, is the dog adequately trained?
Great. Just scrolling down for a few questions here. We have a number of questions, Ms. Jarvis, I believe you already answered this, but we have several questions about people asking, did you have document? Actually, no, we did not ask this yet before. Ms. Jarvis, did you have documentation from a healthcare provider that Roscoe was your supporting?
Of course I did. But he never even asked me about that. Mr. Cantor just wanted to just discriminate against me when he asked me what was wrong with me. My God, like, you don't do that. That's discrimination, and I could sue him, and that's why I'm here talking to you, Judge, because that's discrimination. That's my support animal. It's not up to Mr. Cantor to decide whether or not he's appropriate. He's appropriate for me, and that's all that matters. I'm sorry.
Mr. Cantor, did you ask Ms. Jarvis what was wrong with her or why she needed or did you ask why she needed a support animal?
I certainly would not inquire into something so personal with her. Many years of professional experience have taught me better than that. I just wanted the documentation showing that it was a support animal so that it could be provided to the association for review.
And Mr. Cantor, are there any policies relating to emotional support animals in the condo docs? And were any of those documents given to her prior to Ms. Jarvis signing a purchase and sales agreement?
Unfortunately, the condo documents do not have provisions for emotional support animals. They are under the umbrella of the state law. And so the only mention of pets, not support animals, is that they must be 15 pounds or less.
Okay. We do have a few questions here that I'm actually going to rule out of order. I'll explain why a little bit later on. And let's see if we have more questions here. Okay, and this is for Ms. Jarvis. Is Roscoe a service animal that's trained, or is he an emotional support animal that's not trained?
Well, all I know is he's my support. I have paperwork from my doctor, and that's good enough for me. It's good enough for Roscoe. And where I go, Roscoe goes, and that's just the way it is.
Right. And one more from Ms. Jarvis. Is Ross, you don't have to show him on camera, but is Roscoe with you now?
Of course he is. Of course he is. I don't go anywhere without him. This is his little sister.
All right. Thank you. All right. I think that we are out of questions here. Hearing panel, any more questions? Give you one more minute just in case before I excuse the parties. All right. Comment here, that's not fair bringing a puppy into this. All right. Actually, I will ask a question about the puppy. Is the puppy, Ms. Jarvis, is the puppy, you said that's Roscoe's younger sibling. So is the puppy also a trained or also a support animal or any kind of service animal?
No, that one is a pet
Okay.
because that one does not comfort me like Roscoe does. No one comforts me like Roscoe. I am more Penny's support human, actually.
Great. All right. I think the final question is also to Ms. Jarvis. Did you give the doctor, Ms. Jarvis, did you give the doctor your medical letter to the association itself, saying that Roscoe is a support animal?
I couldn't get to that point because Mr. Cantor decided to just get rid of my whole purchase and sales agreement. He wanted to just make it go away. He didn't ask me for any of that. He accused me basically of just making it up. And so he never even asked me for any paperwork. So there was no need for me to produce it.
Did, as far as you know, did Mr. Cantor present the purchase and sales agreement to the seller? Ms.
We
Jarvis?
didn't get that far. He just told me that it wasn't going to happen. They'd never accept it. And that was the end of that.
Thank you.
I really wanted that condo.
And Mr. Cantor, did you actually present the purchase and sales agreement to the seller?
The purchase and sales agreement was not presented to the seller. At the time that Roscoe was first mentioned, after the buyer had signed it, I discussed that without the proper documentation, this offer would never be taken seriously and offered to withdraw her offer. to destroy the purchase and sales agreement.
And so did Ms. Jarvis direct you to tear up the purchase and sales agreement?
She became so emotionally heightened at that moment that I wasn't entirely sure, but I operated under the assumption that she was comfortable with moving forward with the destruction of the documentation.
All right. Seeing no further questions, I am going to excuse our parties. Thank you for your testimony today. We will follow up later on today with a ruling.
Thank you, Your Honor.
Right.
Thank you.
Okay. This court stands in recess. Ms. Jarvis, you can thank you. All right. I think that we're actually ready to vote here, folks. All right. So I'm going to give you a little help here about a couple of potential articles of the Code of Ethics that could be at play here. And then you may think of some others yourself. So Article 1 of the Code of Ethics talks about submitting all offers as quickly as possible. And so that requires a broker to present all offers as quickly as possible and objectively. Okay, and then we also have Article 10. And Article 10 prohibits discrimination or denying equal professional services to someone for reasons of disability. So those are a couple of the articles that might be. We're not going to vote on them separately. All I want you to do, or all I would like you to do to help me make my decision, is just vote on yes or no and whether there was a violation of the Code of Ethics. So Bailiff Bell, would you like to explain the poll and post that for everybody?
Yes, I worded it just a little bit differently, Monica, so you're just gonna pick
Yes.
who, just pick a person who you agree with, is that, but okay.
No, that's
So I
perfect.
will-
I wanted you to explain it, so yeah.
Okay, so choose Marissa or Dwight, and here we go. Again, if you're on a mobile, you might have to tap on the bottom of the screen to bring up that poll, but you should be seeing it now. And they're coming in fast and furious, Your Honor. Oh,
See
a lot
that.
of people are very passionate about this one. They're coming in quick.
Okay.
We've got 44. It's slowing down a little bit. We'll give you a few more seconds to get your vote in.
Thank you. Appreciate these polls, Bailiff Bell. So,
All right, I'm going to end it. You tell me when you want me to share the results.
all right, go right ahead.
All right, here we go.
Okay, it looks like we have a landslide in support of Marissa. 75% of you thinks that Marissa should win. 25% of you think that Dwight should win. Okay, I'm going to go, like I said, you might have thought of some other articles. The Code of Ethics, if your training comes back to you. Yeah, I would say certainly in Article 1 that there is a violation, so that Marissa would win on that. Because Dwight just Mr. Cantor flatly refused to present the offer. And I'm losing my wig. I'm getting hot under the collar here. All right. Yeah, so he just flatly refused to present the offer. So I agree with all of you on that. And then also the discrimination case. I know emotional support animals can be very, it can be controversial about what legitimately is an emotional support animal. Does someone have the necessary paperwork? I found this a little bit of a closer call, except for the fact that, and this again goes to the credibility of the parties. If Dwight Cantor said, you know, what's wrong with you? The condo association will never accept an emotional support animal. I mean, any indication, statements like that certainly would be, I would see those as in violation of the Code of Ethics, so an Article 10 violation. Now, a better way, and some of you might, I see some people are starting to post a Q&A. I mean, I think a better way, since there are people, I know one thing that Marissa Jarvis had said that made me hesitate was initially when we'd had some questions, or you would have some questions about her documentation for her animal. She's talking about just having like a harness on the animal's back and not really any kind of documentation. And she later said that she did have documentation. But yeah, in real life, if you were actually on the receiving end of someone, whether someone's trying to buy in a condo association, someone's trying to rent an apartment, a house, a condo, whatever it might be, yeah, legally you were entitled, or the owner's entitled, to ask that applicant for documentation that something is a service animal. So, I'm sorry, support animal. Support animals are not trained to do anything in particular normally. A service animal is normally a trained dog, and they have specific certifications. So an emotional support animal, what you need is for a medical professional to actually write a letter saying, on the person's letterhead, saying, this individual, so in this case, Marissa Jarvis, that she is disabled in some way, not what the disability is, but she's disabled in some way. And this particular animal, Roscoe, the Great Dane, is medically necessary to help her with one or more aspects of her disability. So that's something that you're legally allowed to have. Someone can't just say, no, we have a no pets policy. The Condo Association prohibits animals of 15 pounds or over. We can't do those things. Anyway, so in both cases, I would say based on the testimony, I would find Mr. Tanner in violation. Had he worded his request differently about the documentation for the animal instead of saying what's wrong with you, then I know he said he did say in his testimony, he said, no, I didn't say that. Again, I have to weigh on credibility, so I'm going to go with Ms. Jarvis on this one. Okay, so I'm going to agree with the audience, the 75%. There were a couple of questions I'm just going to mention quickly before I turn things over to Anne for the final survey. But there were a couple of questions that someone had asked, and I did kind of reword one of them. But if someone asked, if you're really on a hearing panel, like they kind of don't want to ask, like, what's wrong with you, or why isn't your animal with you? I think there are better ways to phrase that question, so I tried to do that myself. Because the thing is, you want to try and be objective to both parties and make them feel as though they had a fair hearing. So you don't want to seem like you're favoring one over the other. One judgment call I did have to make was, as you saw, Marissa Jarvis was kind of breaking down and being very emotional. And I hope I did act objectively, but it's hard because you see someone crying and you want to say, take a moment to compose yourself, but you don't want that to sway the ultimate decision. Okay, so I have probably talked long enough. So let's see if we have anything in the Q&A. Any comments about? I think I agree with the majority of you. So let's see. Do we have any questions, Bev?
There are a couple. One is asking for some general guidance on rules regarding service animals versus support animals. And I think you covered a bit of it, but if you wouldn't mind paraphrasing again for us, Your Honor.
Certainly. And actually, as we have, we do have a guide that if I can volunteer Bev to send it. I haven't given you this one, Bev, but I've got a 2-pager that kind of summarizes what the rules are and is some links to the actual laws and official government bulletins. The main thing is that with a support animal, as opposed to a service animal is a dog. Like 99% of the time, it's a dog, and it's specifically trained to do something for a person who is disabled. So it's actually gone through training. Maybe it's a seeing eye dog. Maybe it helps someone who's hearing impaired and like barks if it smells that there's a fire or something like that. But it's trained to do something. A support animal can be pretty much any kind of a household animal. There was an issue before with people trying to pass off miniature horses. Some of you might have seen things about what's happened at airports. Like someone tried to bring in a peacock on a Delta airline flight and said that was a support animal. People have tried to bring snakes and boa constrictors and things like that, saying this is my support animal. Pot-bellied pigs. All kinds of animals. So HUD, the federal agency, Housing and Urban Development, came up with some rules just at the very start of COVID, a bulletin to clarify that, and they said. I'm blurring the two terms. A support animal doesn't have to be trained to do anything, but it does have to be some kind of a household item, a household pet. So like something like, a rabbit, a turtle, dog, cat, something that you find as a household pet. And I do have a nice little thing with clip art that shows what kind of animals are acceptable. Be happy to send that out to you. Okay. Maybe I'll be less long-winded for the next question, Bev.
Well, it kind of goes
myself.
It piggybacks, and I think you kind of touched on this as well, legitimate documentation for support versus service animals. I think you said for a support, It just needs a letter from a doctor. Is that true? Or,
Yeah, a doctor saying that the person's, a letter, a doctor, a medical professional saying that the person's disabled. Not what kind of disability, but just saying this person is disabled. And this particular animal, Roscoe, I forgot how much he weighs, 120-pound Great Dane, 5 years old with gray and black markings or whatever the animal looks like. So it's not just a generic prescription that someone can get any kind of animal they want. It has to be something that's medically necessary. So like a doctor writing a prescription, kind of like that.
and the service animal would have a lot more paperwork, I'm assuming, is that?
A service animal is a little trickier because if it's obvious what the service animal's trained to do, like think of seeing eye dog, then you're not able to ask. So it can get a little bit tricky, but I would encourage anybody who has questions, feel free to contact me at the Realtor Association. I get a lot of questions about these, happy to give any resources. And then what I would like to do before we run out of time, I want to make sure I hand everything back to Anne. And if you have other questions, please continue to, or comments, put them in the Q&A. But Anne really wants to hear from all of you. Anne is our Director of Professional Development. And so Anne, do you want to thank the actors first, or do you want to go straight to the survey?
No, I think it's appropriate to take my hat off to you, Monica, hang them high from now on. And also to Jean and to John as well. I almost called you Dwight. But thank you so much for participating in this. This is our first round of hopefully future endeavors where it's kind of this kind of theme. I can see from the audience's reaction, there's 61 of you, and that includes us too. Thank you so much for giving us your vote of confidence. And just as a small token of our appreciation, probably first on the list should be Monica for deigning to wear that wig, which I know is probably causing you some kind of overheating. Thank you for that. But if we were going to do this in person, I would be handing out these little mini Oscars because your performance was exemplary, especially for the first time. Monica, how you handled all the questions. We had 112 questions come in. So thank you. 112 questions. Some of them were repetitive, but again, what we're going to do now with the recording, we're going to kind of compile all the questions. If you've got extras that we weren't able to present during the program, please email me. It's ann@rirealtors.org. You know, this is what I come to work for every day, to be able to provide you with, education, training, conversation, whatever it looks like about your needs as they present in the field. So again, thank you to all of our actors. Can I see you, Jean and John? Round of applause for you. Thank you so much for this. I'm just completely overwhelmed. For once, I'm speechless.